If you're about to challenge your termination from a state agency through an SPB hearing or State Personnel Board hearing, there are two key important things that you need to know before going to that hearing. The first thing that you need to know is that your rights at an SPB hearing are separate and distinct from any rights that you can have to making claims in court. When you go to court and you file a lawsuit, the main claims that are available to you are a discrimination claim in violation of state or federal laws, such as disability discrimination or racial discrimination. You also have the option of bringing a retaliation claim in violation of state or federal laws and unlawful harassment claim. There are other types of claims that you can bring in court, but these are three main types of claims that employees normally bring against their employer that form a basis for a wrongful termination case. When you are at an SPB hearing, your rights are governed mostly not by the state or federal law, but by the employer, by the state's own policies. These rights include the right to a progressive discipline, meaning you should have the right to have maybe first warning, second warning, and then last chance agreement, and then termination. You may also have the right to not be terminated without just cause, and other types of rights. Again, these rights are very different to the rights that you have under state or under federal law that you can enforce in court. So, the two processes, the lawsuit and an SPB hearing, they're governed by different sets of rules and different sets of laws, and the proceedings take place in different places. One goes to court, state court or federal court, and the other one goes to an SPB office. The other important thing that you need to know is that in some cases you might potentially have a strong case that you could bring in court and not so strong case in front of the SPB. And in other cases it's the opposite. You might have a strong case for SPB but not so strong case for the court. The important thing to know is that in some cases, if you lose an SPB hearing, that decision becomes binding on any subsequent civil case, on any subsequent lawsuit. So if you lose that case, then you cannot file a lawsuit anymore after that. And in other cases, just because you lose your SPB hearing, it doesn't have a binding effect, and you can still have the option of bringing a lawsuit in court. So what does this mean to you? This means that before you go to an SPB hearing, it's very important that you meet with an experienced attorney who can look at the facts of your case, at the facts of your termination, to evaluate whether your SPB case is strong or weak, and whether your potential civil case is strong and weak, and make a legal and, more importantly, practical determination of whether you should go to an SPB hearing, or whether, as it is in some cases true, whether you're better off skipping that process altogether and just filing a lawsuit. Every case is different, every situation is different. Now, you may feel that you've been treated very unfairly. You may think that you've been terminated illegally, but just because you feel that way doesn't mean that the law is on your side, and doesn't mean that the SPB rules are on your side. That's where an attorney comes in. That's where an attorney can objectively evaluate your side of the story and the employer's side of the story. And that's why it's so important for you to start your conversation with an attorney by presenting your side of the story, and just as importantly, by presenting to him the employer's side of the story, such as a notice of adverse action or a prior decision, maybe a scaly decision that was adverse to you, that explains where the employer is coming from, because this will give your attorney a preview of where the employer is headed at a future hearing, which will be very helpful in building the right defense and making the right and the most effective arguments for you, both in court and at an SPB hearing. Thank you.